Hello, and welcome back to Coin Lady channel. Federal judges are finally beginning to understand the public's displeasure with the SEC. Nobody in the crypto world, in any crypto group, has felt that annoyance as strongly or as long as we in the XRP community have. We've put up with the jackass behavior of the SEC's pricks for close to 2.5 years now. The good news is that this should be ended for us shortly, at least in theory, and that we should soon have excellent news regarding secondary market transactions for XRP. However, for the vast majority of crypto enthusiasts, the long and arduous road has just begun. Furthermore, I've long maintained that anyone who comes into this with a clean slate and simply learns the facts and arguments that the SEC has been putting forth against XRP and pick your crypto, really, if you just come in and hear both sides, you'll come to the conclusion that the SEC is not operating in good faith. I'm telling you, the SEC has been exposed for what it really is in case after case, whether it's the Ripple lawsuit, the Voyager case, the Coinbase case, or the Grayscale case. They were also erroneous if they thought judges couldn't tell when they weren't being intellectually honest and acting in good faith. David Schwartz, therefore, offered some commentary. I'm going to give you the complete and unabridged set of his statements on the subject. And attorney John Deaton chimed in, referring to the judge, saying, "The court is calling the SEC's bluff," end quote. And this with regards to recent changes in the SEC versus Coinbase case. I'll be sharing the opinions of numerous legal professionals with you in this video. But before I explain, there's something I need to make perfectly clear. I come from no financial or legal background. I am not qualified to give you financial or legal counsel. Nothing I say or write should be used as a basis for making any financial decisions. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. First, let me set the table, and you might think, well, my table's already set, son, I don't need this even if you remember the specifics. Hold on a second, I think this is going to make a lot more sense if you just listen to me. Please allow me to share a few important details before we hear from David Schwartz and the attorneys in our community on this matter, as opinions on the latest development yesterday evening are divided, with some lawyers believing it to be a victory for Coinbase while others hold the opposite view. Others disagree. Given the unusual circumstances, I feel compelled to point out that while the SEC did sue Coinbase a few weeks ago, it was Coinbase that initially filed suit against the SEC in April. The current situation is certainly unusual. That's why the latest turn of events, which I'll discuss below, is being seen as good news by many people. Here's a headline from Reuters dated April 25th of this year. An angry Coinbase takes rare step to get SEC to clarify crypto confusion. That's a great headline, despite the fact that it practically hides the main point. This is not a typical news story, but then again, neither are the circumstances surrounding Coinbase lawsuit against the SEC. Are 9 months too long to wait for regulatory action? Reads the Beast. Coinbase Incorporated argues in a recent appellate petition that the SEC should, instead of policing crypto through enforcement actions, it should instead supply the industry with a clear set of rules and regulations. Coinbase, which revealed last month that it is under investigation by the SEC, has filed a petition with the Third U.S. Circuit Court of Appeals, urging the SEC to propose and adopt rules governing the regulation of securities that are offered and traded via digitally native methods, by July 2022. What happened was that in July of last year, the SEC sought out the SEC for crypto-related recommendations. The SEC is doing nothing, and Coinbase, to their credit, has had enough of this inaction and is taking some preventative measures. They took legal action by submitting the writ, or lawsuit. Essentially, I'm asking the judge to order the SEC to stop being so lazy and start doing its job. In fact, that is the main point they are making. Nonetheless, the situation seems a bit odd. Look at this, then. It's highly unusual for a lawsuit to be filed to hasten the regulatory process at a government agency. Coinbase Chief Legal Officer, Paul Grewal, said the mandamus petition was filed on Monday night in a blog post. To urge an appeals court to intervene only 9 months after a formal request for agency action is even more rare, as shown by the precedent cited by Coinbase's Gibson, Dunn and Crutcher attorneys in the mandamus petition. Rarely do firms that rely on federal regulations succeed in getting an appeals court to force a federal agency to respond to a rulemaking petition, but when they do, it's usually because of a delay of years rather than months. Therefore, the point being made here, and one that is not lost on me, is that it is not unheard of for a writ to be filed asking a court to intervene, demanding that a government agency do its duty. However, doing so after only 9 months is highly unusual. However, from Coinbase's point of view, which is still, I think, a reasonable point, it's not the length that concerns, but the reasons for the lack of action. But I wanted to be sure to emphasize that because Coinbase did win here, and that's why some people are thinking things like, wow, I thought that this whole thing was just going to be thrown out, thought it was going to be dismissed, but it wasn't. At this point, it appears that the court is not buying the SEC's reasoning and instead is holding their feet to the fire. So, consider this. And that brings us up to date. There was a remark made by Paul Grewal yesterday night. That person serves as Coinbase's top lawyer. Also, he promised that this screenshot will appear in its full glory below. I can skip over that part. I'm going to read you something that Paul Grewal wrote, and you can pause if you like. The Third Circuit has ruled that it will preserve jurisdiction over our challenge to the SEC's inaction on our petition for basic rules for crypto, as written by Cheryl N. Krause and Paul Grewal, the plaintiffs in the case. In another 120 days, a report is expected. We appreciate the court's commitment to further illuminating the SEC process, which has hitherto been conducted in complete obscurity. As a result, the court chose to put the ball in your court rather than throw out the case altogether. You've got a whole 2 months to reply to this annoying letter. The message was retweeted by attorney John Deaton, who claimed that the SEC would be forced to offer a genuine update on October 11th. The court seems to be calling the SEC's bluff here. The court had the option to dismiss, but instead decided to retain jurisdiction. I hope that clarifies my reasoning. To emphasize how unusual this circumstance is and how simple it would have been for the judge to dismiss the case, I will go into some background here. However, the judge did not dismiss the case, even though they sued the SEC 9 months after initially filing the relevant paperwork. A period of 9 months. That's an intriguing fact. Certainly a plus. Now, David Schwartz has chimed in, penning a letter to Paul Grewal about it all on Twitter and describing the unfolding events as a roller coaster. Yeah. As you can see, David Schwartz seems to have some conflicted views about this, but I respect his opinion. Look at this, then. According to him, the court ordered the SEC to provide a timeline for its decision on Coinbase's petition. Yay! However, the court should allow the SEC 4 months to report back on their progress toward a staff recommendation. It's safe to say that nobody was expecting Coinbase to gain anything from this situation. I thought it was a publicity stunt at first. In that respect, this is a successful outcome. Perhaps the most optimistic interpretation I can provide is that the fact that Coinbase was granted any relief at all suggests that at least one other federal court, if not many more, share our exasperation with the SEC. That makes sense, all right. That sums up how I feel about it pretty well, because, I wasn't really sad about it. That's why I welcomed news that Coinbase was challenging the SEC in court. Since most businesses in my industry are simply reactive, I get really excited when I see an exception. Therefore, I enjoyed witnessing that. Having said that, I was skeptical that anything useful would come out of it. Furthermore, I am not sure if this will lead to anything worthwhile in the long run. There must be some significance to the fact that this wasn't quickly dismissed. These judges, in my opinion, are cognizant of the SEC's present strategies and the extent to which the agency is not acting in good faith. I wonder if this court would have given serious thought to such an action if that weren't the case and the information wasn't so widely known now. It's something that's had me wondering. John Deaton, an attorney, subsequently shared David Schwartz's tweet. And Deaton stated, Gensler becomes a political liability in an election year because of the cumulative effects. Nonetheless, it may result in his dismissal and a less combative attitude toward the area. Then there's Bill Morgan, an attorney in the large town. He also retweeted David Schwartz and declared the event a win for Coinbase. Here we see another instance where the SEC is having trouble obtaining the quick victories it once did in court cases involving cryptocurrencies. Exactly. What I'm observing is that judges are aware of the issues faced by their counterparts in other courts. Plus, I keep witnessing case after case where the judge must be wondering, okay, what the hell are these little SEC attorney hellspawns going to bring at me today, upon hearing the arguments from the SEC lawyers? You must be wondering what the answer is. They'll be annoyed and frustrated when they see it, though. That's been the case in every single one of the high-profile cases I mentioned at the beginning of the video, and it's been the case all year long. It's the judges, not the defendants, who are applying the pressure and pushing back against the SEC in these instances. It speaks volumes. This is why I feel the need to express it again. This is the fate that befalls a government entity that gains a reputation for acting dishonestly. Resistance is encountered. And that seems to be happening here as well. Some people, however, disagree. That's totally acceptable, by the way. I value hearing alternative viewpoints and arguments on this. Fred Rispoli, an attorney, shared his thoughts on the matter. I won't ever try to manipulate you. Coinbase lost money on the deal. All in all, this lawsuit is just a performance. In its reply brief filed on June 13, SEC requested that the Third Circuit provide it 120 days in which to submit its recommendation to the Commission. Coinbase demanded a quick review by the courts. Now, if that doesn't work, it wants the court to order the Commission, not the staff, to make a decision within 60 days. Additionally, it claimed that the periodic reports were a mirage. Although the Third Circuit would not grant an outright dismissal, it did grant SEC's other requests. Those are undoubtedly valid and sensible concerns to have. To some extent, I think it all boils down to, what did you expect coming into this? Personally, I didn't have very high hopes. This means that I will gladly accept anything. However, I do see where he is coming from. It's the same old nonsense, asking for 60 days and then getting 120. Therefore, the SEC has plenty of time, and any communication will come through the staff rather than the Commission itself. In a nutshell, yes. Oh, I see. Oh, I see. Your arguments are valid. James Murphy, an attorney, shared his thoughts below. And he and attorney Rispoli exchanged a few words back and forth. Thus, Twitter famous lawyer James Murphy concluded, on balance, this is good news for Coinbase. The SEC has been instructed by the Third Circuit to let the court know in October whether or not it would grant Coinbase's motion for rulemaking. The odds favor Coinbase if the SEC claims it hasn't determined before then. Then, attorney Rispoli added, would you consider this a loss for Coinbase, though, aside from dismissing the case, the Third Circuit gave SEC everything they asked for and none of what Coinbase requested based on the 120-day deadline for a staff decision? This was in response to the initial question of whether or not the case dismissal was a win or loss for Coinbase. I wouldn't expect any real progress until at least 2024. I do think the pendency of this case benefits Coinbase in the more crucial enforcement matter, attorney Murphy answered. Every brief will mention how the SEC still won't commit to rulemaking or not. An SEC tactic is haziness. The SEC will be just as helpless as you were. Yeah. To that end, I'll pause to mention that, as I'm sure many of you are aware, attorney Rispoli now has two significant litigation pending against Coinbase and the SEC. In any case, Attorney Murphy here is pointing out the tactic. Everyone knows that. The haziness is well known, of course. That's why everyone always brings it up. That is also the case here. Even if you consider the valid concerns that Attorney Rispoli raised, it's still evident that Coinbase didn't acquire a whole lot of what they were after. This is the point that Attorney Murphy is making. Attorney Murphy seems to be arguing that the continued existence of this issue will aid Coinbase in the SEC's pending case against the company. So, I see now. It's as good as it gets. Do you understand what I'm saying? It's all about how you look at things and what you expect to happen. Finally, Attorney Rispoli answered to Attorney Murphy by saying, "True, in the end, the Third Circuit did not dismiss the case. And I assume despite the delay, that's the win, which, as you state, I would also celebrate as a great win if Hodl Loss, that's his law firm, gets through the request to dismiss." And then Attorney Murphy said, "Good luck, Fred. The significance of your lawsuit against the SEC to have the court rule that ETH is not a security is probably underappreciated. It would be a major victory to overcome the SEC's move to dismiss." Yep. So, I guess, subjectively, I'd assert that I'm coming at him from all directions in this situation. In my opinion, we've still come out on top. But again, given my vantage point, I wasn't anticipating much. Coinbase admitted Attorney Rispoli's claims that they did not get some information, but they requested these information anyway because they believe it will help their case. That feels like a win to me. That being the case, I'll accept it. Feel free to share your opinions with me. It depends on who you ask. Therefore, there is no single correct response. However, please share your thoughts with me. Let's continue talking about this. I think it's great that there are so many judges here, because the SEC no longer has a reputation for acting in good faith. In the future, I believe that this information will be useful for any case presented before these justices. Simply said, I think it increases the likelihood that the SEC will have a tougher time and get away with less and less nonsense. Just so you know, I'm speculating there. To me, at least, that seems to be the case, as I can't think of any other explanation for the SEC's recent streak of unsuccessful court cases. Now, there appears to be an issue. The SEC has not been functioning in good faith, and the courts have been calling them up on it. I am not a certified financial planner. My words here should not be used as a basis for making any financial transactions. Please like and subscribe my channel. See you in the next video. Bye.